Hi, my name is David Shapiro. I'm a San Diego-based criminal defense attorney, and today I'd like to discuss with you possession of a controlled substance for purposes of sale. These are offenses usually when you have someone with a large amount of drugs found on them, whether in their actual possession, like in their wallet, in their car, or in their constructive possession. Say, for example, if it's found in your room, whether you're home or not. Prior to November of 2000, these cases were actually a little bit easier to settle if you were in a situation where you had a significant amount of drugs on you, but maybe didn't have a prior criminal history, because once the case can be proven, you might be able to go in there and negotiate a simple possession charge. The problem is, and the good and bad of something like Prop 47 in California, passed by the voters in November of 2014, is that now simple possession of controlled substances, for the most part, are misdemeanor. But if you have possession for sale, it is a non-reducible felony, which means if you're convicted of that, it's a felony and will remain a felony for the rest of your life. So the essential elements, obviously, that you possess a controlled substance, a lot of times we concede that element if it's actually in your possession. And the issue is what could be proven, whether or not the only reasonable interpretation of the evidence is that you possess those drugs for sale. Now, a lot of times law enforcement and the prosecution will get hung up on the amount of drugs, but all these things are factored in the totality of the circumstances. The amount is really important, don't get me wrong, but if the drugs are packaged a certain way, if there's text messages on your phone, if there's pay and owe sheets, indicative of someone who's selling drugs, if there's admissions that you were possessing it to sell, so on and so forth, those things all go in hand on how a case is charged and how a case ultimately resolved. So just because you may have a lot of drugs on you, if you keep your mouth closed when questioned by law enforcement, and if there's not those other normal indicia of sales, such as, like I said, text messages, baggies, pay-o sheets, all those types of things, you have a pretty strong defense to maybe argue, hey, simple possession. There's other issues as well in these types of cases that generally relate to search and seizure issues, how they found the drugs, why your vehicle was pulled over, why your room was searched, why your body was searched, all those types of things. And then there's also proving that you, in fact, did have the drugs in your actual possession or you're in constructive possession. So there's a lot of defenses to these cases, provided, the main thing is you keep your mouth closed and hire yourself a good lawyer. And there's certainly avenues of defense and avenues of successful defense if your attorney knows what they're doing.